Okay. So we are talking about trash. We're talking trash, and we're talking about profiles, and we're talking about we've got the defense attorney with the Idaho State Police lab manager, Miss Nowlin, on the stand. And we've just gone through in video 3 that they got a profile from a parent or child of Mr. Kohberger from the trash. And they also got a profile that was a majority male and a minority female. And that later, it sounds like that sample matched Bryan directly, but the Idaho State Police did not process that sample, that mixture. Okay. So Miss Nowlin just said, well, we didn't do that. Okay. So the defense attorney is saying, did you and I have a discussion a few days ago? We did. And she asked, did you tell me that you knew that to be Bryan Kohberger's DNA? And the Miss Nowlin says, I said I thought that was, and I could not find the report where we had done the comparison. I've since looked through, and we, meaning Idaho State Police, did not make the comparison. So I cannot say that he was included in that mixture. Our laboratory did not do that comparison. So she says, defense says, but a DNA profile was made for that mixture. Is that right? Yes. And in that mixture, there's a minor female and a major male. Miss Nowlin says, that's my understanding. And the defense says, and you could, by eye, look at that and tell that it's Bryan Kohberger, couldn't you, if you wanted to? And Miss Nowlin says, if I wanted to, I could probably look. I did not. And they look at it. If you've ever seen the graph, there's a series of, okay, this is STB testing. Okay. Kind of like they look at ridge detail in the fingerprints, they look at detail in the profile. Okay. So the defense says, okay, you could still do it today if you wanted to. And Miss Nowlin says, if there was a request to do the comparison, again, we don't do a visual comparison evidence to evidence. Our procedures don't allow us to do that for probative comparisons. Remember, I talked about probability. So I'm probably talking about the machine doing it. So the defense says, I need you to help me understand that a little bit. I'm having that question because I understand there was an unknown male B found on lab item 30. Do you know what I'm talking about? And Miss Nowlin says no, and we don't know what item 30 is. So, okay, here she goes. So she says, okay, well, I also understand that there was a cigarette butt taken from somebody in connection with the case investigation. Are you familiar with that? I'm so confused. Okay. So Miss Nowlin says, I'm familiar with that. And the defense asks, and that was compared to the DNA on the knife sheath. Is that right? Yes. And that was found to be excludable. Am I using that word right? It was an exclusion. Correct. So what she's saying is that they got item 30 is a cigarette butt. So they got discarded. Somebody must have discarded it. They were doing surreptitious, I'm assuming. Could have been in the trash, but who knows? And they pulled DNA from that cigarette butt and they compared it to the DNA that they pulled off the knife sheath. And it wasn't the same. So whoever person B is, and whoever, let me see, it was compared to, okay, so unknown male B is the cigarette. And I believe Bryan is number A. That was compared to the DNA in the knife sheath. Is that right? Yes. And that person was excluded. Yes. Okay. So here's the defense attorney asking. So you compared something that was taken from somebody to an item of evidence. Remember, we've got our file folder system. And she says something that was a secondary reference, as in someone identified it as they saw that person using the item. They saw that person dispose of that item. That item was collected and used as a reference sample from that person because there was someone who said that is from that person. So it sounds like surreptitiously they got the cigarette butt and somebody assigned, I'm getting a little questiony here, if we logically think this through with the way that Miss Nowlin is answering this. Somebody assigned that cigarette butt to a person they were looking at, a person of interest. So the defense says, okay, when you got the trash to go through in the lab, you knew you were looking for a male, right? Correct. And you knew that the male and his family members lived in a house that produced the bag of trash. Is that right? Yes, but not who produced each individual item in that trash bowl. Okay, right? We talked about that. Probabilities. Okay. Miss Nowlin continues. It wasn't labeled, this water bottle is from person of interest. This tissue is from sibling. This Q-tip is from a parent. We didn't have that information. It was just, here's some items from a trash pull, right? So maybe when they saw somebody toss that cigarette, they saw the person toss the cigarette and they say, you know, Johnny, cigarette butt from Johnny. Okay. So within this trash, this mountain of trash, the defense is saying you developed male E. I think that's the dad, right? Or no, yeah, that's the dad or the child. Okay. And she says, I did not, but yes, the laboratory did. So she says, in general, your lab developed male E. Correct. And compared male A and male E. Okay. Male A, knife sheath. Male E, trash pull in Pennsylvania. And Miss Nowlin answers, there was a paternity statistic calculated because they were both single source profiles, meaning only from one individual. And the defense says, okay, and there's another male profile. So she's asking her, okay, so what the defense is saying, male A was the STR profile developed off the knife sheath, and male E was developed off the trash, which said it's either the father or the child of male A. Now, and they were only single source, easy peasy. Okay. Now the defense is asking, but there's another male profile. And Miss Nowlin answers, that was part of a mixture, to my knowledge, meaning more than one person's DNA present on that item. That's that majority male, minority female. And the defense asks, again, only one male though, is that right? So Miss Nowlin says, so when there's a mixture on an item of evidence, I don't know if you want me to explain the process. The first step is determining the number of contributors, remember our pen, to that mixture. Then our laboratory utilizes a software program to help break out the components of that mixture. When one individual is male, it's not always possible to say the gender of the second person. Males have an X and a Y, females only have an X. So if there's an X and a Y present, it could only be one male. It could be two males. It could be a male and female. Without comparing to known reference samples, I can't say that, and I haven't seen the profile. So, the defense says, did you tell me, though, on that sample, and I'm talking about 95.9.1, that has to be another of those trash items, that it was a male and female? And Miss Nowlin says, I believe that. I don't know if it was designated as that in the laboratory report. To my knowledge, it was. I can't remember what the report said. Again, I didn't generate the report and I didn't do the work, so I'm not as familiar with it as if it was my own work. So the defense says, okay, male B was also a mixture, wasn't it? And I believe, I'm not sure, male B, I didn't write them down. I didn't know we were going to get into all this, who's on first. I believe male B was the banister, but I'm not sure. Okay, so the defense says male B was also a mixture, wasn't it? She says, I don't know. So, okay. Miss Nowlin says, if it was designated as unknown male B, again, I don't know if it was from a mixed sample or not. And the defense says, just a couple of other questions. As it relates to male E, it was compared to the sheath. Is that right? Correct. A paternity comparison. And the defense asks, male E profile was compared to a lot of other evidence items in the case, wasn't it? Correct. And the defense says, and you are allowed to do a manual interpretation per your policy, right? Miss Nowlin says, if there is, so it's not black and white. So if it is a single source, we can look at it and say that the person is excluded. They are not the source of the DNA. Then yes, that can be done manual. And by manual, I mean a person looking at it. If it is a probative comparison, probability, I mean, how probable is it that it's this person or not this person? She says, and how we define a probative comparison is if it's saying something about who could be the source of the DNA on an item of evidence that's relevant to the case, then no, we do not do a manual comparison and issue a statement about that because of our standards. We have to issue a statistic so that the trier of fact has something to gauge how unique that could be. What is the likelihood that the DNA could be from somebody else? That's a probability. We provide that statistic. We just don't say it matches. That requires a statistical calculation, which we use a probabilistic genotyping software to do. So, it's either going to say, yes, it's him, or it's probably, right? Okay. So, defense says, I apologize. I think I got lost in there. Are you telling me, because it was a mix, you couldn't have done a manual interpretation on 95.9.1? I think that's an evidence item. And Ms. Nowlin says, because it's a mixed profile, because if it was, you're saying it was Bryan's DNA, Bryan Kohberger's DNA present, that would be a probative comparison in the case, which we have to provide a statistic in order to make that statement. In order to deconvolute a mixture, means separate it, we are no longer allowed to do those manually. Deconvolute, as in separate the mixture into its components. We have software. The software was not designed for, nor was it validated for doing evidence-to-evidence comparisons. Okay. So the defense attorney says, now you're speaking my language. Validations are important for integrity. Is that right? And Ms. Nowlin says, in forensics, our laboratory uses validations to ensure any new tool is working properly. Defense asks, now at some point later, your lab issued a report saying, matching the DNA on the sheath with DNA taken from Bryan Kohberger. Is that right? And Ms. Nowlin says, that's correct, and a statistic was provided. Defense asks, now I want to talk about what we're talking about when we say the sheath. You're familiar with what happened with the sheath for swabbing, is that right? Oh, goodness. Oh, God, help us. Okay. Ms. Nowlin says, I don't know what's happened to it, so I don't know. This is going to, we'll see what happens. Okay, Ms. Nowlin says, I've seen the sheath, and I know how our laboratory performs swabbing of evidence, but I did not swab that item of evidence, nor did I see it being swabbed. So defense says, as I understand it, though, you've read the lab notes. Ms. Nowlin says, at one point, I believe I did read the notes. I think I was asked a question, and the analyst was out of town or something. Well, doesn't the manager like go through the cases every now and then or something, like a high profile case like this? Like you wouldn't be checking. I don't know. I don't know what her duties are, but okay. So the defense says, and I think you answered that question to law enforcement after consulting somebody else who was with the swabber when the sheath was swabbed. Is that right? Ms. Nowlin says, it's sounding familiar. So defense says, if I understand the lab reports, it's a single source on the knife sheath. Is that right? Correct. Does that mean it's only one person in that area? Yes, that was detected through our testing. So defense says, tell me where you think that sheath was swabbed for purposes of DNA collection. And I'm going to interrupt myself here because I was always like, you mean to tell me on a big old knife sheath, like the only speck was right there on that snap? Really? Sorry, I just had it, like, we're going to see what happened here. So defense is asking the same thing. So Ms. Nowlin says, I believe the analyst swabbed there's kind of a snap or button that was the top of the snap. And that's the area that was swabbed. Oh, there were other areas on it sampled as well. Thank God. Defense says, for the purposes of unknown male A, that you're telling us later came back to Bryan Kohberger, that's the only place I want to talk about right now. Are we on the top of the button, the outside, or on the inside, the socket portion of the button? Now we have to think about a snap, right? So the snap on the sheath, from what I understand, like here's the sheath, you know, the snap comes down, right? So you have that, where my fingernail is, you got that metal portion. And when you flip it up, there's that indented portion that goes on the, right? That's what she's talking about. This, she's asking, was it on the top of it or was it under the underside of it? Or, yeah, because it's the snap. Now it could be the bottom piece here, you know. It could be right here because, like, I know on my gun holster, I go, you know, we're taught to you swipe it. You don't pick at it. So we could have here, we could have here, and we could have right here. Okay. Defense question. For the purposes of unknown male, okay, so are we on the top of the button, the outside, or on the inside, the socket portion of the button? So Ms. Nowlin says, I know, on the top. Oh my God, help us. I don't recall if she swabbed the underside or not. I'd have to look at her notes again. For my detectives, if you're listening, please call me about lab procedures because there is so much evidence that is not being tested because the labs are deciding what portions to swab and what portions not to swab, and your contract may be unknown to you determining how many swabs you're getting. Disgusting. Okay. And I don't know what she did. Okay. I'm just saying. All right. So Miss Nowlin is saying, I know that the top was swabbed. Here's our holster. I know that the top was swabbed. I don't recall if she swabbed underneath or not. Miss Nowlin says, do you know if that sheath was part of that preserved for fingerprinting? Okay. I'll do her answer, then we'll talk about it. The swabbing was done first. That's our laboratory standard order of processing. If DNA is needed and fingerprints, they will work together. Essentially, latents, that's what they're called, fingerprints. She's talking about the fingerprint portion of the lab, will say, we can see some possible ridge detail. So if you can avoid this area, after DNA says we want to swab this, and they come to a decision of what would be best to suit that item of evidence to determine where to swab. So the swabbing takes place first. So it sounds like, because one can mess up the other. Sorry. So they're going to look at it and they're going to say, we got a good fingerprint here. Don't, because they're going to smear it. They're going to get rid of it. Okay. Because it's oil and everything that leaves the, washing your fingerprint off. Okay. So you got to choose which one do we want. So someone's going to say, fingerprint might say, don't do here. DNA said, but we got DNA here. They got to decide. Sometimes it's a either or, unfortunately. Okay. So swabbing takes place first, because then you're going to get the dust in there. Okay. So the defense says, I don't have any other questions. Thank you. The judge says, how long do you think you have? And the prosecution says 10 minutes, because he's going to come back on cross. Okay, so the court says, let's take the 10 minutes and we'll be back. Okay, so they take a little break, and Mr. Nye from the prosecution comes back. So he's asking again, Miss Nowlin from the Idaho State Police, I just have a few questions. So you talked about policies and procedures in the lab. Do you recall that testimony? Yes. And you talked about that there are policies and procedures related specifically to DNA. Is that correct? Correct. As part of those policies and procedures, does the lab need to have a legitimate reason to test DNA? Yes. We only test DNA related to criminal investigations or to death investigations, and it needs to be an item that will answer a probative question in a case. What's the probability that this person did it versus this? Okay, is this a piece of evidence or not? So the state says, so for example, if someone at the lab wanted to test DNA out of curiosity about medical information, that would not be consistent with that policy. And she says, no, we don't do curiosity testing, and none of our testing would provide medical information. And I believe that they're saying this because, if I remember correctly, the defense argued, I believe improperly, that it was a HIPAA violation. Okay. So the state says, you also testified that you were involved or maybe primarily responsible for developing the scope of work request for Othram. Is that correct? She says, I was part of that. Yes. And he says, and what is a scope of work request? She says, that just goes with, and this was my first one I've done, God help us. So I don't have vast experience in this process. But when we're going to contract with a vendor, just going through and outlining what we expect them to do as part of that. And what do you recall that this request specifically? What were you requesting Othram to do? Specifically, we were requesting them, if necessary, if necessary, to perform DNA extraction. Pulling the DNA out of the cells of an item of evidence, if necessary. Our lab typically did that. We were requesting them to generate a SNP profile using either SNP array or whole genome sequencing. And for my detectives, SNP array is way more cheaper. So check your pricing out and come talk to me because y'all getting ripped off. Okay. We were requesting them to upload that to all public databases that allow law enforcement samples. We were requesting them to generate a report, preliminary, whatever. We were requesting them to notify us or to complete the lab portion of the work, generation of the profile within 60 days, I believe. I believe there was also information in there about not publicly giving our case information to the public without our express permission, things of that nature, because they got crap all over their website. Okay. He asked, was there anything in the scope of work requests related to medical information? No, he's going to hammer this home. So you weren't asking Othram to determine if this DNA, the person whose DNA this was, had, for example, cancer? No. Now, in your position, and in this case, you testified you didn't actually do any of the testing, but you've read a lot of the reports that were involved. Is that correct? I've seen a lot of the reports, correct? And of all the reports you've read, have you seen that kind of information? It's referring to medical. She says no. The testing our laboratory doesn't generate any medical information. And you talked about in the scope of work, Othram was required to provide you with at least one report. So she says at least one report, correct? And did you have a chance to review that? I have seen that report, yes. Did it contain medical information? No, it did not. Now, you also talked a little bit with Ms. Taylor about an MOU. Do you remember that discussion? Yes. I just want to be clear. Who were the parties to the MOU? Memo of Understanding. The parties to that MOU specific to this case were the Moscow Police Department, the Latah County Prosecutor's Office, and the Idaho State Police Forensic Services. So Othram was not a party to that, correct? And the FBI was not a party to that, correct? In another part of your testimony, you spoke with Ms. Taylor about the trash pull. Do you recall that testimony? Yes. And that one of the samples that was pulled from the trash was a mixed sample. Your lab did not compare that. Is that correct? Correct. And can you explain why you did not compare that? So initially, we did not compare that because it was a mixed profile. We did not know the source of that profile, so it could not be considered a secondary reference. So we deemed that to be an evidentiary sample. Okay. And we can't make a manual comparison of evidence to evidence, especially when there's a mixture. And if the analyst, again, I was not the analyst, if the analyst did the comparison and determined that unknown male A could have been in that mixture, it would have been inappropriate to compare our samples together per our analytical methods. So State says, so the decision not to compare that, who made that decision? And she says that would have been the analyst working the case. So you weren't, to your knowledge, no one at the lab was advised, for example, by the lead investigator on this case, which one of those items to test. Crazy town. Crazy town. No. Crazy town. Sorry. You also gave some testimony about the knife sheath and the swabs on the knife sheath. Do you recall that? Yes. And I know you don't recall exactly where the knife sheath was swabbed, but we've been talking about policies. Do your policies or best practices suggest where a knife sheath or an item like that should be swabbed for DNA? No. It would be impossible for our analytical methods to cover how to swab or where to swab every single item of evidence. We receive quite a wide variety of items into the laboratory. So it's the analyst's job as a scientist, as a practitioner in forensic biologically screening and DNA analysis to know what they're targeting. And I'm going to interrupt here for my cops. The analyst, the person sitting at the bench, and I mean no disrespect to the person sitting at the bench, but think about this. The analyst has not walked through the crime scene. The analyst does not know how the item was held. Was it a striking motion? Was it a swiping motion? Did something fall on it? Did somebody bleed on it? Was it cast off? Was it used as the weapon? Get what I'm saying? That is the person deciding, okay? I had a case, I'm going to tell you guys now. 56 inches of material. And they took one piece of this and left 55.9 of it and never tested it, never swabbed it because the analyst chose where to swab and they had a limitation on swabs. You are leaving evidence on the table, literally, on the bench. Okay? Sorry, get off my soapbox. Okay. You need to direct what's important to you. You are the detective. You have been out on the crime scene. You have seen the crimes committed. You may have encountered the suspects. You have heard the witness testimony. Not the lab person, and God bless him, that comes in every day and pulls something out of a box or a Ziploc bag and swabs it. Okay? Please. Okay. So now Ms. Nowlin continues. So on this item, the sheath, I believe there was also blood. So they would have been targeting that separate. Okay, so where's the blood on the sheath? And then also trying to determine who may have handled that. So they would have specifically honed in on an area that whoever handled it would have had to have touched, and maybe touched repeatedly. And why do they hone in on those areas in particular? Because that's the question we're trying to answer. In forensic DNA analysis, the question we're trying to answer is, can we link assailant to victim, victim to assailant, or one or both to the scene? So in this instance, my understanding is the sheath was found at the scene. Just there. It was just there. It was just there. Was it a weapon of the suspects? Was it a defensive item? At the scene, it's just at the scene. Okay? Knowing that a specific type from the coroner, I don't want to get graphic here, but knowing that a specific type of weapon was used, and that type of blade, edge, or whatever is the exact same type that goes into that sheath, would probably tell you that the suspect carried the sheath. Again, hypothetical. But there could have been a bat at the scene. And the victim, people come into houses to create mayhem and carry a bat. So the bat could be the suspect weapon. But the homeowner could also have a bat and could have beat the crap out of the suspect with the bat. So whose is it, right? Okay. Sorry. So the state is, we're on recross. The state says, and why in particular do you hone in on the areas where this person may have handled the knife sheath? Because DNA is found in the cells in our body, and that includes the skin cells that are sloughed off on our hands when items are handling. So looking for any touch DNA. This is the term that is most often used, or from someone touching or handling an item. So he says, so if I'm understanding correctly, the analyst is swabbing the places that would most likely have touched DNA. Correct. No further questions. Redirect. Okay. So Miss Taylor is coming back at her to address what the prosecutor said. So, okay. So they're going back and forth about Ms. Taylor the defense wants to show her a computer screen so they could refresh the witness's memory. They're going back and forth about that. And so they're talking their attorney language about, can she remember it or can't she? Are we just going to agree that she can't remember it? And so then they're going to stipulate. So that means both sides agree to it. Okay. So Ms. Taylor, the defense, says, We were talking at the end of my questions and where Mr. Nye just left off with you about where the sheath would have been swabbed. Reading the email in front of you, does that refresh your recollection about what you believed to be the place the sheath was swabbed? And Miss Nowlin says very much so. And the defense says, where was it swabbed? And it says, the knife was swabbed the entire, and then the judge says, did you say knife? Right? Because that's what I said. Like, we're talking about the sheath. And the witness says, sorry, the knife sheath. So she says, am I allowed to read it? And Miss Taylor says, you're supposed to read it and let it refresh your recollection and then not read it, but just tell me a summary of where it is. So when the witness doesn't remember, they'll say, if you look at the lab report, will that refresh your memory? And so they're supposed to read it quietly and then say, okay, yeah, I remember, and then talk about it, not read it verbatim. Okay. So Miss Nowlin says the entire leather portion of the strap, both top and bottom, and then the underside of the button. Okay, so not this part here, not the rest of the sheath, but this part, the strap. So this part, and this part of the strap. She says, I misspoke. Oh, interesting. The entire leather portion of the strap, both top and bottom, and then the underside of the button. So she didn't do this. She did this part. And she did not do this button. Oh, because it was determined to be the most likely place for fingerprints to be found. Yes, because when you, if we're using, like, if this is our, hopefully you can see that, you know, our sheath strap, you're gonna, right? Okay. Sound effects are free. Okay. So the defense says the underside of the button, was it the part, this is crazy, but I have this question. Was it the part that the sticky out part would go into? Oh, up here, or the sticky out part, or both? Okay. So, you know, when you have a snap, you've got the, what's it called? Convex, right? So the part on the top is like this, and the part on the bottom is like this. So it snaps on, right? So the defense is asking, was it this part or was it this part? And Miss Nowlin says she doesn't know. Okay, good enough. A couple follow-up questions. You were asked a lot of questions about medical information. Your lab does not do testing for medical information. Is that because you do STR or YSTR testing, not SMP testing? Correct. Our laboratory performs both STR and YSTRs, and those don't yield medical information. Okay. Defense is still asking. The MOU that you reviewed and remembered the Department of Justice interim policy applied to the circumstances in this case. Do you know who else the interim policy applies to? And I talked about that in video 3. Ms. Nowlin says, based on what is stated in the interim policy, it applies to public laboratories like ours that receive federal funding in cases where federal funding is being used. So she has to follow it. In Mr. Kohberger's case, there was federal funding being used. And she says, to my knowledge, I don't know if we use federal funding in this case. And the defense says, do you recall talking to me a couple days ago? She says, yes. She says, and do you recall telling me that you did? She says, I do recall telling you that we had a grant in place. But again, I authorized payment of the invoice, but which funds the funds came out of, I don't know. And I apologize if I misspoke. Okay? And I talked about that for my detectives. You don't want the policy to apply. Defense says, are you aware that the FBI Forensic Genetic Genealogy Unit, I guess, took over and the FBI finished the genetic genealogy after Othram was stopped? She says, I'm aware we were authorized to turn it over, but as to what happened after that, I don't know. Okay, one more question for you. You talked to Mr. Nye, the prosecutor, about not comparing the sample 95.91 to the sheath DNA. And I had asked you a little bit about your policy that allowed you to do the hand search, the manual search on that. Your policy does allow you to do a comparison, like it's either excluded or not excluded though. Is that right? And I'm looking at policy 4.5.6. And she says, no, we can report an exclusion. They aren't from the same source. But in order to say they are from the same source, considering they're from completely different areas, no, we would have to provide a statistic, and we can't do that. But you could have looked at it and said it's not excluded. She said that would be an indication that it's possible, and we would have to provide a statistic for that. And we have. So our biology section, you may be looking at our analytical methods. Biology section has their own quality manual that further discusses this. So it sounds like what she's trying to get at is, in looking at it, she would be able to say more likely than not, no way is that the same person. Or she would be like, looks pretty good. Okay. Even if it's not formal. That's what it sounds like she's getting at. And so Ms. Taylor then says, Your Honor, can I have it refresh your memory? I'm showing her a couple pages out of the biology manual for the Idaho State Police Forensics Lab that's available online. She asks her, look at the very bottom one. That's the one I'm having trouble squaring with your testimony, if that refreshes your recollection. So Ms. Nowlin says, so what this is talking about, as it may be beneficial to make a qualitative statement about evidence to evidence comparisons. However, there's another section of our biology quality manual that specifically states that if it's a probative comparison, a statistic must be provided. Okay? So they're talking about qualitative statement versus probability comparison. Okay? And she goes on to say, so for instance, if you're in one room in a scene and there's multiple swabs that are tested, we can say that these are consistent or these appear to be from the same unknown individual. Now, if I'm going to say that these are from John Doe, we have to provide a statistic for each item and do a comparison of each item. So the defense says, did I hear you compare? You could compare if they're probative, okay? And probability, like these legal words, probative. So she says, if it's, which that wouldn't be, in mind, a probative comparison, we have multiple items of evidence in the same room in a scene. We can say they appear to be consistent with the same unknown individual. That's not making any statement about who that individual might be. If I'm making a statement about who might be the source of that, then that's a probative comparison. I need to provide a statistic. Okay, so they're splitting hairs here about, common sense. Because they're going to get this swab and get a profile, and they're going to get this swab from the same room. It could be from the same house. They're going to get this swab, and they're going to compare them. They're going to be like, same person. But what she's saying is when you make an ID, okay, because when you get the STR from the suspect, that the person that they're interested in, it's going to look the same. But she's saying, so we can compare evidence samples from this crime scene and say, yes, that's the same person, but we can't make the ID without the probability statement. And you get these things like it is 1 in 19 million quintillion, things like that. Okay. So she has to provide that statistic. Okay. So the defense says before you make the comparison where maybe you write an exclusion, you don't know if it's excluded or included though. Is that right? And she said, can you repeat that? So the defense says, yeah. Let me explain what I'm getting at. I'm not understanding why 95.9.1 couldn't have been manually looked at to do a manual comparison to the sheath DNA just to say excluded or not. Meaning like, no way in hell is that the same person. Or, looks kind of close. We might have got something, okay? So that's what she's saying now, a manual comparison. When male E, which is the cigarette guy, I think, was compared to multiple items of evidence and was excluded. But you don't know that until you do the comparison. Is that right? So she's saying, correct. You can look at it manually, but if we're now making a probative statement, we have to provide a statistic. And male E was also a single source, which is different than a mixture of DNA from multiple people. All right. I don't think I have any other questions. Okay. Semantics. Okay. You can call your next witness. Okay. I am going to stop it here because we're at 46 minutes.